All right, it's 11:01, so we might make a start to today's webinar. Welcome to the International Social Service Australia Preventing International Parental Child Abduction webinar. And I'd love to welcome everybody today. We've got nearly 200 people who've subscribed to this webinar, so it's really great to have everybody on board. For those of you who don't know me, I'm Peter Van Vliet. I'm the CEO of ISS Australia. And may I begin today's event by acknowledging the traditional owners of the land on which we meet today. For ISS Australia, on our Victorian office, we stand on Wurundjeri land, and our New South Wales office stands on Gadigal land. And on behalf of all attendees and presenters today, we pay our respects to elders past and present, and any Aboriginal and Torres Strait Islander peoples who may be here today. I would also like to acknowledge our ISS Australia board members who are with us today, including our President, Fiona McIntosh, and other board members, including Deborah Fry, Peter Arnado, and Susie Winakoska Matonga. The ISS Australia board does wonderful work in leading and supporting our organisation, and it's just great to have you all here with us today. I'd also like to acknowledge ISS Australia's new gold sponsor, Rafton Family Lawyers. They've just undertaken a corporate sponsorship arrangement with us, and we're very proud to be associated with this specialist Sydney-based family law firm. For those of you who don't know much about ISS Australia, we're a leading Australian not-for-profit and charity providing legal, social work and mediation services for children and families separated by borders. We're part of a global network of around 130 members operating throughout the world. And for the purposes of today's webinar, ISS Australia is funded by the Commonwealth Attorney General's Department, where we provide legal and social work services to families impacted by international parental child abduction. And we do thank the Commonwealth for their ongoing support. As you know, our webinar today is focused on preventing international parental child abduction, and we have three speakers today who will speak on the topic. I'll introduce them now rather than during the event. Firstly, we have Ms. Kay Harderfeld. Kay is a qualified social worker, mediator, and manager of ISS Australia's International Parental Child Abduction Support Service. Kay will outline the role that ISS Australia plays in supporting families impacted by international parental child abduction. And Kay will also be today launching ISS Australia's new publications, Connect. And these are companion resources for mothers and fathers who are separated from their children because of international parental child abduction. And these resources will be available on our website. We will then have Commander Andrea Quinn. Andrea is a commander of the National Operations Coordination Specialist Protective Command with the Australian Federal Police. Commander Quinn will speak on the AFP's Family Law Watchlist, which identifies when listed children are travelling overseas and may prevent or limit such travel. Finally, we have Ms. Asha Kutcha. Asha Kutcha is the Acting Director of the Complex Case Management section of the Department of Foreign Affairs and Trade, DFAT. Ms. Kutcha will speak on the Child Alert Request System, which may allow persons with parental responsibility of children to ensure special scrutiny of any Australian passport applications. And also available today to answer any curly legal questions we may have is our acting managing lawyer of ISS Australia, Jenny Tam, just in her first week as acting. So welcome, Jenny. I'm sure you'll do fabulously. For housekeeping, we have a comments box for any discussions and a Q&A box if you wish to ask any questions. There will be a short Q&A session following the formal presentations. We're expecting the seminar to go for around an hour, so we should wind up at around 12, but we can go a little bit longer if there are questions that people wish to have answered. Keep your comments respectful, positive, professional. We'll moderate comments and questions to ensure this, so we keep this as a very positive and professional event. So that's basically all of the housekeeping done and all of the introductions, and have a great webinar. And I'll now hand you over to our first speaker, Kay Harderfeld. Thank you.
Thank you, Peter. All right, I'm just going to share my screen, so just bear with me. What I thought we'd do by starting today is just going over some fundamentals. So looking at the definition of what is international parental child abduction. So the acronym for that is IPCA. So as I'm going through today and if I'm talking about IPCA, I'm talking about international parental child abduction. So IPCA is where a parent takes a child overseas or keeps a child overseas without the consent of the other parent or without the permission from a court or relocation. So IPCA can take two forms in the way that it actually occurs. The first form is in terms of retention. So this might be where a family or a parent is travelling overseas with the child for the purpose of a holiday, or it could be to visit an ill or unwell family member, and it's supposed to be for an agreed period of time, but they overstay and they decide that they're not actually going to return to the country where they would normally live. So this is retention, and this fits the definition of international parental child abduction. So we also have removal. So removal is more the typical type of child abduction that we all think about. So this is more where a parent might come home from work, they've found that their child and the other parent is gone. And, you know, they're really distressed and they find out that they've actually left the country and taken the child overseas. So both of these equally fit the definition of international parental child abduction, regardless of the way they've occurred, whether it's retention or removal. I want to briefly go over the Hague Convention. The reason I want to talk about this, even though it's probably familiar to most people, is because if it is a Hague Convention country that's involved, then there is a straightforward legal process that parents can follow in order to try and have their children returned. But if it's not a Hague Convention country involved, then it's a lot more complicated, it can be a lot more costly and time consuming. So that's why I just want to cover this off today. So put very simply, the 1980 Hague Convention is a piece of international law that says that if children are taken from the country where they would normally live by a parent to another country where they wouldn't live normally without the consent of the left behind parent, that they should be returned to the country where they would normally live in a prompt way. So it's a legal mechanism that allows parents who are left behind to make an application for the return of children. And our legal service can assist with that. We're funded from the Attorney General's Department to assist with those applications for children who've left the country under the Hague Convention. So there's 83 countries where that are enforced with Australia that are signatories to the convention, and in order to use the convention, both countries that are involved in the situation need to both be signatories to the convention and recognise each other's accession to the convention as well. So there's 83 different countries. And the Hague Convention is only available if the children are under 16 years old. So that's the Hague Convention. I want to talk a little bit about how common international parental child abduction is. So according to our statistics, we know that a minimum of 2 to 3 children are taken into or out of Australia every week. We expect that the numbers are probably higher than this, the actual numbers. That's because we don't always see all of the incoming cases where children are abducted to Australia. And not all families come to our service. They might choose to go to a private law firm to do the application, and then but just may not come to our service. So we expect that the numbers would be higher than 2 to 3 children a week. The reason that we want to talk about preventing international parental child abduction right now is because we know that families have been under significant pressure during the pandemic. We know that relationships have been under pressure, and we have had a lot of relationship breakdowns over this time as well, which has been widely reported in the media as well. So with international travel about to resume, there's never been a more important time for all of the professionals in our sector to really be across what IPCA is, how you can prevent it, and what the risk factors are. So that's why we're here today. I want to talk a little bit about our legal service. So our legal service provides advice regarding IPCA, and they also provide casework services as well. So this is a national service. It's funded by the Attorney General's Department. There's no cost associated with it, and there's no eligibility requirement for advice. And advice can be given to people affected by IPCA or who are likely to be affected by IPCA, regardless of whether it's a Hague signatory country or not that's involved. Our lawyers can also give advice on prevention and relocation. The only limitation is that they can't provide advice to taking parents. So that's where, say, a parent has brought their child to Australia without the consent of the overseas parent. Our legal service also do provide casework services, so they can provide assistance with preparing affidavits and documentation for Hague return applications. There is also a second function of the Hague Convention, which allows parents to make an application for access or contact with their children overseas. And that separation, or however the family came to be separated across international borders, is less important for that access function of the convention. It could just be that the parents have decided to live in separate countries and the contact arrangements have broken down and they're wanting to re-establish that contact with the child overseas. So that's a good thing just to be aware of. We also have our bilateral agreements with Egypt and Lebanon. So they're unique agreements between Australia and each of those countries, and our legal team can assist with making applications under those agreements as well. Okay, so let's talk about our social work service. It's free. It's again funded by the Attorney General's Department, national service. We provide casework regardless of whether it's a Hague country or a non-Hague country that's involved. And unlike the Hague Convention, our social work service can be involved regardless of the age of the child. So the Hague Convention cuts out at 16, whereas we can be involved and support families regardless of the age. And it could also be someone seeking support as a young adult if they were abducted as children, and seeking support around that as well. We also provide support to extended family members, parents, grandparents, aunts, uncles, anybody who has concerns in the community. And we also provide advice to professionals and assistance to professionals as well. So please feel free to reach out to us if you ever need our support or assistance with any of your clients. So the majority, the majority of our clients are left behind parents, and most of them are fathers. And I will come to that in a couple more slides when we talk about the breakdown of mothers and fathers. But we also assist taking parents as well. So this is what I was referring to before in terms of incoming abductions. So if a parent has come to Australia with their child, they might have found themselves involved in a Hague court proceedings here in Australia, and they might need some emotional support and referrals through that process as well. So we're certainly here to assist. So it's a much broader scope, I guess, our social work service. And we rely very heavily on our international network as well. So we're making referrals to our overseas partners. We're making child protection reports through our overseas partners. We're outreaching parents. So our social work service has that kind of added benefit with the network as well. So some of the common familial characteristics that we have noticed with families affected by IPCA where one or both parents have dual nationality with the country apart from Australia. So usually that indicates that their family support might be overseas, and sort of that extended family support network. So it usually does involve young children. So we're talking sort of 5 years and under. And what we know is that the majority of taking parents are mothers. So just looking at our stats, our legal stats over the past 3 years, and we know that nearly 80% of outgoing Hague applications actually involved taking mothers. So generally it's with families, or the taking parent has limited supports available to them in Australia. And as I said before, extended family in the overseas country of origin. And usually we see that there's been those prior threats to take the child as well. And abduction is usually occurring at the point of separation or soon after the parent's separation. Some of the reasons why parents might take children are relationship breakdown, financial problems or difficulties post-separation, lack of support networks, which we've kind of covered, family violence. So it could be a parent has concerns about their own safety and their child's safety and are taking their child in an attempt to protect their child. It could also be somebody taking their child as part of a broader pattern of family violence and control over that left behind parent. So it can happen in both scenarios. And it can also occur in the context of family court proceedings where a parent is not wanting to engage in lengthy relocation or parenting proceedings, or is expecting an outcome maybe that isn't going to be in their favour and is preempting that and taking that action. So this is what a risk assessment or a framework that we use when we receive inquiries from people who are concerned that their child might be taken out of the country. So what we're usually doing is we're trying to assess the immediacy of it. So where are the children right now? Are they with the parent that's calling? Are they with the parent where there's a risk of abduction? Are they at school? Where are they right now at that point that they're calling? What kind of country is involved? Is it a Hague signatory country? If it's not a Hague signatory country, we know that the process is significantly more difficult and significantly more costly and time consuming. So if it's a non-Hague signatory country that's involved, then it's really important just to take that action and to help that parent take that action to ensure that the children are not taken. If you're ever not sure whether a country is a signatory to the convention, you can always call us and ask us. We're really up to speed with where it's all at, and sometimes the accession table can be a little bit confusing. So just if you're ever unsure, just give us a call. The age of the children. So if they're under 16 years old and it is a Hague Convention country, then there might be a higher possibility that they might be able to put a return application in. But if they are over 16, knowing that actually the convention wouldn't even be applicable, even if it is a Hague Convention country. So just keeping that in mind, as well as whether there's been any prior threats to abduct the children as well. So passports, checking out where the passports are, what kind of passports the children have. So in Australia, we know that both parents' consent is needed for an Australian passport, but a lot of parents are not aware that if the child is eligible for dual citizenship with another country, they may be able to get a passport from that country as well. And not every country requires both parents' consent for a passport to be issued. New Zealand is a really good example of this. So a child's passport in New Zealand, you only need one parent's consent for that passport to be issued. So sometimes, and I have had calls from parents in the past where they said, oh, I had their passport secured, I thought it was fine, but not realising that the parent had actually got passports from the other country, given the child was eligible for that dual citizenship. So it's a really good thing to keep in mind. And the Family Law Watchlist, which we will hear more about shortly, is, in my experience, the most reliable prevention mechanism that we have in Australia. And it's very rare that I don't think I've ever heard of children being taken when their name is actually on that list. So it's a really good mechanism that we have to try and prevent child abductions in Australia. One of the advantages of being so regional and surrounded by water. So I want to talk a little bit about the impact on left behind parents. So what we know over the years of supporting parents who've had their children taken is that they're usually in a point of crisis. So they're usually feeling quite overwhelmed by sadness, they're in shock. There's a lot of grief and loss and confusion and isolation as well. There's not the same level of understanding in the community around what it means to have a child taken overseas. And you don't necessarily have the same level of support from family or friends that you might have with other significant events in our lives, where there's a real recognition that someone might need that additional support. So that isolation is something that we hear a lot of as well. And that's why we have our social work service available to parents in these situations to help them through that. What parents report to us are physical impacts, so changes in appetite, changes in their behaviour, maybe behaving in ways that they wouldn't normally behave, difficulties sleeping, difficulties focusing at work. So there's real physical impacts as well. And the increased risk of suicidal thoughts and behaviours. So research shows that parents, when they go through separation, are generally at a higher risk of suicidal thoughts and behaviours anyway. But when you compound that with international parental child abduction, the loss of that relationship, not only with the other parent, but with the child as well, can really magnify those feelings. So we are working with a very vulnerable group of people who need a lot of professional support and referrals to mental health supports when this comes up as well. And support, obviously, navigating the legal processes as well, whether it's a Hague Convention country or whether they're needing to pursue family law court action in the overseas country. Parents often need a lot of support through that process as well, especially given the emotions and the feelings that they're going through as well at that time. So this is some research about the long-term mental health impacts for children. So there is a correlation between the length of time children are missing and the more significant mental health impacts of that child abduction. So the longer, the more significant the mental health impacts. So when we look at this smaller no real effect group, which is nearly 9%, so that could be where the child was only taken for a very short amount of time and was returned very quickly, or it could be other things like the child knew or didn't oppose travelling overseas with a parent, knew that it was going to be a permanent change and didn't really resist that, for example. And the very significant mental health effects are sort of the situations that we see where the child might have been told that the other parent is dead, They might be living a very transient lifestyle in an attempt to evade authorities. They might be told to use different names. All those sorts of things can really magnify those mental health effects for children, and also keeping in mind that length of time. And that's why it's really critical that parents seek advice early. And if we can prevent it, that's the ideal measure, but is seeking assistance early to have the children returned as promptly as possible to minimise this mental health effect. Okay, so what I want to do now is just quickly launch our new resources. These have been probably about 18 months in the making. Let me just make this bigger. And we have some companion resources that are specifically there to support and assist parents who have had their children taken overseas. We will be sending a link to this to all participants, so you will be able to have a look at this if you're interested. There is a little download button here, and I'll just quickly go through it. So we have one for mothers and one for fathers. They're marketed quite differently, but the content is very similar between the two of them. But the referrals are quite different as well. For example, we've got men's line in the father's resource, and we've got different referrals in the mother's resource when it comes to referrals and different connections. So let me just see if I can make this a bit bigger. Great. All right. So just going through this, it's a bit of a magazine style, so it's easy to read. We've got images throughout. We've got some information here about the impact of abduction. We've got quite a bit here on the loss and the grief that the parents might experience associated with IPCA. We have some really good tips here that have actually come from parents telling us over the years the things they've done to help them get through these difficult times. So we sent this resource out to our client group. We got a lot of feedback in relation to the presentation and the content, to making sure that it was reflective of the experiences of the people that we're working with, and making sure it's really informed by them. And these practical ideas for staying connected, again, have come from parents. And there's some great tips in here. So some really creative tips as well. One of them, for example, a parent was separated from their child for a number of years, and they set up an email account for their child. And over the years, they sent emails and photos to this account. And then when they reconnected as adults, when the child was now a young adult, they were able to give them the login details and share with them all of the emails and all of the photos that they'd sent over the years, as a way of showing them how they were able to stay connected with them despite that physical distance and lack of contact. So yeah, these are really good tips, and they've all come from people that we've supported over the years. Again, we've got some contact tips, so how to improve, or tips to enhance that video contact with children when you are cross borders. A lot of these, again, have come from parents themselves who have told us what has worked for them and what's improved that contact for them. We've got legal information about the Hague Convention. This goes over a couple of pages, so talking about return, the process for this, access applications, and we also have non-Hague Convention countries and what support and assistance is available in those situations. We have had quite a lot of inquiries over the years about how to engage with the media, whether parents should engage with the media. And when these kinds of matters do come into the public domain, there's usually a lot of media attention. So we have included a section about the media in here, so some legal considerations and also some personal considerations about how that might impact the family if they do decide to involve the media in their situation. And we've got these additional resources, so co-parenting resources, how to support children, mental health and community services referrals, and obviously where they can get help out of hours and that sort of thing as well. So we're really excited to launch these resources. We feel that they're really evidence-based, and they've largely come from the clients and the people we've been working with. So we're really excited to have them, and you're welcome to have a look and download them and have them available if you need them as well. So you'll get a link to that. But that's everything from me. I'll pass you back to Peter, and thank you very much.
Thank you, Kay, for that rich and wonderful presentation. We're so lucky to have you in our service. Your expertise is just incredible, and those resources are just so fantastic. And we're going to encourage everyone to look at those, because everything you need to know about IPCA from an Australian perspective and an international perspective is in those resources. And congratulations for getting them done. It's just magnificent. Very proud to launch them. So now we move to our next presenter, and we're very privileged to have Commander Andrea Quinn from the Australian Federal Police with us today. We've already had people asking questions about your topic, Commander Quinn, which is of course the airport watch list. So I think we'll hand over to you without any further ado.
Okay. First of all, I don't have a long, very impressive presentation, so I'll just talk through. So if I start at the basics, from an AFP perspective, we have what we call the National Operations State Service Centre that runs 24/7 here in Canberra, down in the basement of the Edmund Barton building, for those of you that may know where I'm talking about. And from an AFP perspective, that's sort of the first point of call for the AFP. So anybody at any time who was wondering wanted to know something from the AFP, including things we don't know, will ring a number 131 AFP, and you'll get someone on the other end of that. And there's police on 24/7 to provide advice to non-police that help answer phones and radios. You can get advice on anything that you need. So that's been in existence for a lot of years now, and is a very good point of call. I suppose when we're talking about children, and Kay touched on family violence and issues that require an immediate police response, always ring 000, your local police, because ringing us will just waste 10 minutes or 5 minutes of time, and that's really important. But if it's a question in relation to a family law watch list matter and things like that, certainly you can call the AFP 24/7. So from the NOSC, the National Operations State Service Centre, from a NOSC perspective, we, just by way of background, we manage all of the police contact from international police and through to Australian police through our international network. We manage that communication through. Interpol is managed outside hours through all the Interpol requests, receiving and processing them on behalf of local law enforcement agencies to go out of Australia, are managed through the AFP. I've got a communications centre down in the basement that manages all of the call outs and responses at all of the airports and the protection establishments that are around Australia, from defence establishments to out in Pine Gap to the airports across Australia. We're there to provide that radio communications and that initial response, for whatever they might need. And probably most significant for today, we also provide the initial call for all the alerts and alarms that the AFP monitors and manages. So we monitor all of the alarms for all of the diplomatic and consular premises across Australia, and we also monitor the alarms for all Australian high office holders and Parliament House and places like that, the Lodge, wherever there's an alarm, we manage all of those. And all of the AFP buildings, we're the worst ones for our alarms going off after hours. So we manage all of that, but significantly for today, we manage the alert list. So the Family Law Watch List is probably, it's part of a broader alert list that Australia has had in place for many years, and I've been in the AFP for many, many years, and it's always been in existence. And it's when you go to leave the country or you come into the country and you see your now Border Force member there doing the processing, that list will have everybody that is of interest or concern for a range of issues. We all go through the one database to check our details. So whether it was a counter-terrorism alert that had been placed on by an agency, or if there was a prohibition order from the Australian Tax Office to stop you from leaving the country, or whatever other kind of reasons we watch people coming and going from Australia, they're all through that same core database. And it's it's sort of not just the special family law alert list, but it actually the Family Law Watchlist is part of that broader database. So we, from an AFP perspective, we would put things for alert, family law recovery orders, family law, which includes stopping children leaving the country. We would put arrest warrants on behalf of state and territory police if they had wanted to know if someone who had an arrest warrant out was leaving the country, because they're probably not going to come back. And the National Child Offender Scheme alerts for those kinds of people that might be trying to leave Australia. We manage all of those alerts for the Commonwealth, aside from immigration, for the Commonwealth, and also for local law enforcement organisations and the tax office and places like that. We would put all of those alerts on, so the requests come through to us. So from a family law watch list perspective, we've got around 10,000 current alerts on at the moment. Once an alert goes on, typically they could stay on until a child is 18, while we encourage courts to sort of put people on for, we prefer 2 to 3 years as a time. If an alert goes on when a child is 3 and no one asks us to do anything different and that court order remains in force, we will leave that alert on. We will not make a decision to take that off because we are acting on the court order. And if the court order were to change, even if the child was 17 and a half and it was it's schoolies and they're going over to Bali, we would not let that person go because there is a current court order in place. That I can't give you any stats on how often that happens, but that could happen. The day they turn 18, we would let them go. So when a court order is issued, the court may send the document to us, or potentially the lawyer of the person who's got the court order would send that to us, and we'd do the entry. And as soon as the entry's done, it's quite quick. It's a data matching, and it's a data matching thing. So when you go to leave the country, the alert will have your name and your date of birth. And to the point that was made by Kay about passports obtained from other countries, provided that first matches the child's name and date of birth and whatever, if that's the match and they're an exact match on a passport and the names are the same, we wouldn't let them go. People are also encouraged to tell us if there's alternate names. So whether we wouldn't necessarily stop someone whose mum had used the maiden name and the child has got the partner's name and they've got a passport from another country in a different name. We might not stop it. It'd be a case by case by the people that attend to that. So when you present yourself to leave or come into Australia, the alert would be activated by the system, and the Australian Border Force will call the AFP and understand what we need to do. And the instructions are contained within the alert of who we call and what we should do. From an AFP perspective, it's really important to note we need an effective order. We can't do anything without an order. We can't do anything without a really distraught phone call after hours in really tragic circumstances. Without an order, we can't do anything. That does include an initiating application, and the wording of those documents must include to stop the child from going overseas. It can't just be for something else. It needs to include in it the wording. And I noticed actually, Kay, on your screen when you showed us your great resources just before, the AFP's got quite a detailed set of guidelines on our external hub. So if you look on the AFP website and look under what we do, and then you see crime type, and if you drop that box down, you get there's family law in there, and that was really good, and actually what I used as the basis of what I'm talking to now. So there's a really good set of resources that goes through some of the things that we can and can't do. If someone fears that an order has been breached and someone has left the country, our advice is that they would seek legal advice, which is, I guess, where it comes back to here and to Kay and Peter and the team. If there's something that urgently they think can be done, dial 000, or you could dial 131 444 to get a police response, 000 if it's urgent. They won't be allowed, if there's a match there, they won't be able to leave the country. And if there's a match and they're coming back, whatever that original order said was, you know, don't do this, and, you know, the child's meant to be with mum, but dad's taken them overseas, we would facilitate at an airport to not have that child continue home with mum when dad was meant to have them. And so we would get as involved as we needed to be in that process. The key points that I think to note is that we can't do anything without an order. We need a court order or the initiating application to do anything, and that's really critical. So we just can't do anything. We need as much information as we can, and I did see something about changed names in the order. You need to give us as much information as you can. So if an alias was put in, you can put an alias in. So in a circumstance where mum thinks dad might get a New Zealand passport in a different name, you would give us all as much information as you can, because a match with the date of birth and the child's name and the alias would make us then go to the presenting people at the airport and say, I need you to prove who this child is, and it's just not an unusual circumstance that they happen to have the same name and date of birth as a child who's on our watch list. So we do act on aliases, and those that information is really important to give to us when we're putting the alert on and to have included in the court orders. And the court orders, as I mentioned before, must be specific about I think they're going to travel. So if the watch floor, the crew that does this, was sort of saying, you know, they're being used a little bit sometimes to weaponise the parent that's taking the child on a Fijian holiday for 2 weeks with no links to Fiji. They're probably going on a holiday and they're going to come back. Court orders would stop that holiday from happening, and the team sort of feels that pressure, but we put the orders on because that's what it says. So they can be used for that, but basically the orders have got to include that the child can't leave the country, and sometimes there's circumstances in those orders that might be a parent can take the child for 7 days to their trip to Fiji and then must come home. And there's certainly circumstances that I'm sure Kay would know better than I, where that trip to Fiji becomes a trip on to somewhere else. It's an offence to take a child out of Australia in a contravention of the court order, and it's an offence for failing to come back in contravention of the court order that's in place. But it can happen. So, you know, all the data matching, if we've let the child go, that things cannot go according to plan when people, you know, legitimately have said they're going on a short trip and then they continue. There's only so much we can do here. And I mean, the final thing is, I said the child can stay on alert till they're 18, which could be a shock for some if they were just under 17 as they went to leave. It's the responsibility of the individual to tell the AFP and provide an updated order, or say the order's been cancelled when the child at any time there's a change. That's the key thing. So we react to the court order, and I hope someone's taking a note of those questions to ask me later. We'll respond to the court order. If a family mum rang and said, I want to take the kids on a holiday next weekend, my husband took a court order out a few years ago not to travel, our advice is, well, you won't be able to travel even if you've reconciled, if that court order's in place, because we respond to the court order. You'll need to go back to the court and get an updated order that removes the condition about leaving Australia. I think that's about it from me. The AFP website, under the Family Law tab under crime type, which feels really bad to say that, because there are a lot of crimes under the Family Law Act in relation to publishing and taking children and not returning them and breaching the orders. But it's under crime type, it's under family law, and if you read through that, there's heaps of resources. And I might make sure, if it's not already there, Kay, that there's a good link to your new stuff on the AFP page. So that's about it for me for now.
That is absolutely brilliant, Commander Quinn, and thank you so much for the work you do every day to protect children in the community. We really appreciate the work AFP does in this area. And you've got a truckload of questions, but I think just to keep the webinar going, we'll get back to those. If there's any that are quite simple that you might be able to answer online, feel free to, but otherwise we'll save them up for our Q&A session later, but certainly created a lot of interest, that presentation. We'll now have our final presenter who's going to talk to us briefly. We're again privileged to have from the Department of Foreign Affairs and Trade, Director Asha Kushta. And Asha is going to talk on the Child Alert Request, which is with regards to passport applications, which is another tool in the IPCA prevention kit bag. So I'll now hand over to Asha.
Thank you, Peter. As Peter mentioned, I work at Complex Case Management Section at Australian Passport Office at Department of Foreign Affairs and Trade. And my section manages passport application when alert is in place or when there are allegations of abductions. The child alert in Passport Office is a warning to the department that there may be some circumstances that need to be considered before issuing travel document to a child. A child alert can be raised by a person with parental responsibility for a child. It has to be done in writing. The form can be obtained from a contact center, and that alert is usually valid only for 12 months unless supported by the court order. When the court order is present, and that can be provided directly by the court, by someone else, by the parent, or also by law enforcement agencies, the alert is in place very similarly like on the Family Law Watchlist until the child turns 18. The Australian Passport Office can also raise the alert for the child if they have any information that warrants such action, and law enforcement agencies can raise alert as well for us. Something that is very important to note, and contrary to what Andrea presented about Family Law Watchlist, child alert in Passport Office does not prevent travel. A child alert also does not prevent issue of a travel document to a child. Each case is considered individually, and depending on the circumstances, if the child is legally entitled to travel document, the travel document still may be issued despite alert being in place. When a passport application triggers the child alert, Passport Office assesses whether to contact the person raising the alert, as there may be the reasons for not doing so. And as an example of that is if passport application includes a court order that extinguishes the alerts raiser parental responsibility. So there is a range of very different individual circumstances which we would assess once the application is lodged, and also based on the alert raised. Allegations of child abduction can present at any area of the passport network. And for these purposes, we define child abduction in the very consistent definition as Kay mentioned at the beginning of the presentation. So that's just simply removal of a child from their country of residence without the consent of all persons with parental responsibility, or retaining the child overseas without the consent of all persons with parental responsibility. My section, the Complex Case Management Section, manage all applications for children at risk of being abducted, that have been abducted, or are potentially being recovered after an abduction. And child recovery is, again, very consistently with case presentation defined simply as attempt to recover a child from country to which the child has been abducted or retained in. Our involvement of Passport Office in supporting parents through responding to abduction or preventing abduction is limited. Role of Australian Passport Office is to determine whether a child is entitled to a passport and whether a travel document can be issued. When Passport Office is notified of an abduction, we do provide guidance from passport perspective only and advise that person that If they are overseas, to contact local authorities, so law enforcement and border securities. And in Australia, we refer them to Family Law Watchlist and Australian Federal Police. And I will just reiterate the same information that both Kay and Andrea said before me. The only way to prevent the child from leaving Australia, even if they have a valid travel document, is to ensure that they are on the family law watch list. We also advise parents to seek support from legal assistance from international social services. When the child is and the family is overseas, we encourage them to contact Consular Emergency Center for assessment whether any consular assistance is available in any particular situation and in any particular location. We also encourage them to raise a child alert to warn Passport Office that there may be circumstances that need to be considered before issuing a new travel document to a child, and to ensure that that application is scrutinized before travel document is issued. And referring to aerial statistics presented by Kay, I would also like to add that Passport Office is only involved when the abduction matter involves passport-related issues. Quite often, we're not involved. We don't know child already has a passport or doesn't need to have a passport, and our involvement and our visibility of abduction cases is very limited. That's it from me in the very quick summary, but I'll be happy to answer any questions if someone has a specific question later on during the Q&A session.
Thank you very much, Director Kuster. That was a wonderful overview of the Child Alert Request System with regards to passport applications. Look, we've had quite a few sort of curly and tricky legal questions, as we suspected we would, and I'd like now to introduce you to our acting manager lawyer, 1 week into the role, Jenny Tam. Jenny's going to attempt to sort of curl them all up into one answer and provide a little bit of a short overview of our legal service, because this is really a question about what happens in effect post-abduction, what might be able to be done, and a variety of questions to that effect. Just be mindful, though, that this is not legal advice and it's not immigration advice. We can only do that we can't provide immigration advice, and we only provide legal advice to clients. This will be more of an overview. Over to you, Jenny, and welcome.
Thanks, Peter. Thanks for the introduction. Yeah, so there have been a lot of questions about, what happens if a parent hasn't been successful in stopping their child from being removed or retained outside of Australia. So it really depends on which country the child has been taken to. So if it's a Hague signatory country, like Kay said, then their parent might be eligible to make a Hague application for their child to be returned to Australia. So our legal service can help the client prepare a Hague return application free of cost to the client, and help them finalise that. So a bit about the process. Once an application is finalised and it's lodged with the Australian Central Authority, then both the Australian Central Authority and the Central Authority of the other country must assess it. So if it's approved, then the application will be lodged overseas in the overseas court system, and a judge will make one decision, and that decision is whether or not the child should be returned to Australia. So there was a question about whether there would be delay if documents needed to be translated, and the answer is yes. Unfortunately, there is delay when documents had to be translated into the primary language of the other country. For example, if it's going to Spain, or it's going to France. So the ACA, the Australian Central Authority, have been very accommodating, and they have tried to get things translated quickly if the application is urgent or there's a filing deadline ahead of time. But there is delay, and how long court proceedings will take, Hague court proceedings will take, really depends on the overseas court system. So each country runs their court differently. Some courts can be quicker, some courts can take months to years to resolve a Hague matter. So it just really depends on the country. And so, if the child has been taken to a non-Hague signatory country, then obviously, like Kay said, our assistance is much more limited and our advice would differ. And we'd rely on the client probably seeking advice from a lawyer in that jurisdiction instead. if the client's child's been taken to Egypt or Lebanon, then we can possibly talk the client through making a bilateral agreement application to seek either the return of the child or access to the child. So it really depends where the child's been taken to, how long ago it's been, and whether they would suit any of the criteria like Kay has gone through. So if there are any questions, more than welcome to answer, more than welcome to ask. Otherwise, clients and professionals can give us a call through our national hotline and our online interactive form, which are both on our ISS Australia website, along with our Connect resources and our fact sheets, which will have more information about the Hague processes.
Wonderful. That's a wonderful summary, Jenny. Well done on doing that at short notice and doing a really brilliant summary of our services. There are a few little legal questions about specific countries in the chats. Jenny, if you might have a go at answering some of those now in written form, that would be fantastic. Commander Quinn, we've got quite a few questions about your area. I'm just wondering whether we can just throw to you and you might be able to summarise answers for some of those.
I'll just unmute myself. I have answered some of those. I'll just go back to I'm technologically challenged here. I've answered a few of those as we've gone through. So I think I've answered, there's five or six. So what protection can you put in place if someone wants to go on a holiday to their home country? The only way that we would be able to stop that travel is the court order, and I'm sure that there's been cases. I mean, there's been cases over the years that that the child has been taken home to whatever country it might be. So the only way that you could guarantee to stop that travel really is through a court order, and we would be able to place the child on the watch list. In relation to the question about putting someone on a watch list, does either party know? Both parties should be aware of a court order. A court order shouldn't be used as a weapon, but they would both know. So if that was to happen and you weren't happy about it, and there's a question a little bit later on about that, you would, if there was a court order that you dissented, you would need to get your legal representative to go to the family law court and say, justify there why you would like a change to the court order, and that happens a bit. What if there isn't a court order from an AFP perspective? We can't do anything. So if you rang to say someone was trying to take the child, you were concerned, we would advise you to get a court order. And the same in relation to the last question that I've already answered. If you object to the watch list and someone being put on the watch list, we respond to the most recent court order. So that's sort of that's what we use to justify the actions that we take, and they're required to take under law. There's a question about addressing holding passports as an indicator of support or claim of being controlling. I'm not answering that. If that was being done in relation to this topic, which is getting the court order, and you were concerned that I was holding a passport and and therefore I was going to take the children, a court order would be how you could stop that regardless of who has the passport. It's about the individual. Ideally, the request would include the passport number, but it doesn't need to. I don't know the question about Israelis. Is that it for me?
Yeah, that's wonderful.
That's
wonderful, Andrea. Thank you so much. Kay, there's a few questions, I think, in your space. Did you want to have a go at any of those?
Yeah, absolutely. So I was looking at the question around, if someone is saying that the passports are being held by a parent in terms of as an indicator of being controlling. Look, I don't think there's any reason that couldn't happen. There's always that possibility, but I think it goes back to what Andrea was saying just a moment ago in terms of the best way to prevent a child from being taken is the family law watch list. So if a parent is concerned that the other parent is controlling and they're also holding the passports, we would encourage them to look at the family law watch list and pursuing that process through the court. So that probably answers that one. In terms of can a child get if a child is eligible for dual citizenship with Israel, can they get a passport? So the best way to clarify that is to actually contact the Israeli embassy in Australia and just to ask them, what is the process? Is it both parents? Is it one parent? That consent is needed. Off the top of my head, I know that New Zealand just has one parent's consent is required. I know that Australia needs two, but I wouldn't be able to tell you every country off the top of my head. And the best way is just to contact the embassy in Australia and to ask them. And I don't know if Jenny has anything she wants to add to that, but that would be what I would normally suggest. Yeah, I think they were probably the main ones. But if I've missed any, I'm happy to answer any other ones as well.
That's wonderful, Kay. Thank you so much, and great job. I'm just thinking, I think we're getting towards the end of the questions. I'm just wondering, are there any panelists who have any questions that we've missed? We'll certainly try to answer all the questions individually. Someone's just asked, I'm not sure, Jenny, if you want to have a go at this, but someone's just asked, what is the interaction between a family violence order and child abduction protections? Jenny, do you have an answer for that question? Seem to have lost Jenny.
Not sure if we still have Jenny.
Oh, yes, here we've got Jenny. Jenny, we just had a question there on the relationship between the family violence orders and child abduction protections. I'm not sure if you're in a position to answer that.
Yeah, so sorry, my video is not turning up, but generally, even when you have family violence orders, that won't stop a child from being retained overseas or removed overseas. So it only is a family law watch list that will prevent a child from being taken overseas. Family violence orders really do come up when Hague Convention applications are lodged and the other party is raising a grave risk defence, and they say that, you know, a return to Australia with the child might put the child at risk, and that's usually when the family violence order comes up and becomes a bigger topic and something that the court also has to consider in deciding whether the child should be returned to Australia, whether the Australian systems have been sufficient enough to protect the mother, the taking parent and the child. So that's usually how they relate.
That's wonderful, Jenny. Thank you so much for that description. Look, I think we're getting towards the end of the session now. And we're finishing right on time, just before 12 o'clock. So I think at this point in time, I'd really like to thank all of our presenters. You've all been wonderful, and hopefully have illuminated this quite complex topic to our, the couple of hundred people that have joined us today. And we'll also have this recorded on YouTube for anyone who's missed it. We'll be sending links out. Kay we'll send out links of the PowerPoint presentations and also of the new Connect resources, which we saw, which are just wonderful. Really like to do a big shout out to Kay Harterfeld, our manager, who's organised this webinar. She's done a terrific job as always, and assisted ISS Australia and myself in getting all of our wonderful panelists. So congratulations, Kay, on doing that. You've been really wonderful. And on that note, Kay, did you have any final words you wanted to say to the group?
Just very quickly, if we have missed any questions, please feel free to just give us a call. Our legal service and social work service is always here to sort of answer and field any questions you might have. So pick up the phone and give us a call if there's anything you're wanting to know specifically. That's all. Thank you so much.
That's wonderful, Kay. And look, on behalf of International Social Service Australia and our partners today, AFP and DFAT, we've really enjoyed having you at this presentation. Thank you again to Commander Quinn and Director Kutcher for your wonderful presentations. And we'll now leave you on this note. And we look forward to, we've got another webinar on next month in the illegal and illicit intercountry adoption space that we would love to have you attend. That's also on Eventbrite. So please feel free to come along to that if you wish. And otherwise, we wish you all a wonderful Wednesday. And thank you very much for your attendance today. Bye for now.